Very good day to everyone. Very good evening, Bilal sir. Sir, we can wait for another 2-3 minutes. Let's everyone join as today is Saturday and few people are working. So let's wait for another 2-3 minutes and we can start the session, sir.
Okay. A very good evening to everybody. We can start the session, Archana.
Yes, sir. We can start the session. One participant is actually traveling, so we can start. Meanwhile, he will join. No worries, sir. We can start. It's already time.
Okay. So welcome everybody. Good evening. My name is Bilal. I will be your instructor for this course. This course is about the DPDA implementation and DPDA introduction to DPDA and its implementation. So this course, as you know, is related to data privacy and how the DPDA is applied to data privacy legislation of India. So I would first like to get some introduction, and also in that brief introduction, I want what is the expectation from this course? What are your objectives for this course? So that we can, we can design the course, or we can proceed with the course with those objectives in mind, so that you can be fully, satisfied, and you can be fully obtaining those objectives at the end of this course. So you can give a brief introduction about your current job profile, your background, and why you are pursuing for this course. We can start
Hey,
with an
hi.
alphabetical order. Yeah.
Hi, Bilal. This is Arvind here. Can you hear me, Bilal?
Yes, yes, yes.
Hi. So I'm into cybersecurity. I don't have a. I mean, so with cybersecurity, privacy comes a point of view. So with DPDPA, I need to understand how it is going to apply in the Indian context for my Indian consumers, and how I have to change my current control sets, protocols, and activities to meet the DPDA requirements for protecting cybersecurity in my company. I hope that helps, Bilal.
Yeah, yeah. Thank you.
Thank you.
Thank you.
Thank you. Thank you.
Hey, hi Bilal. This is Chaitanya from Hyderabad. So I work for a startup. So it's a 10-year-old startup, and we offer IT services. So recently, the DPDPA Act has come into the picture, and it's asking all organization to make sure that they were compliant. And right now, I'm collaborating with the other teams, especially with the HR and all. For implementing this. So the main reason why I have enrolled in this particular training program is to make sure that I'm going to attain the complete knowledge about this thing. I'm specifically looking for as a data fiduciary. I believe that is the right word. In context of our organization, we uh, take care of. Our HR team is much concerned about the how the data is getting processed, and where it is getting used, and how do we make sure that things are there in the place, and how to choose the best vendor who manages this thing. Is there any uh, SaaS-based application or any vendor within India who could help us on this thing? I'm much interested about that. And also, do we have any separate policy apart from the privacy or procedure documents which we have related to the SOC 2, or do we need to create any other procedure document? And what would be the monthly or periodic activities where other departments need to do? Just want to uh, get complete deep dive in this, Bilal.
Okay, okay. Got it. No problem. We will touch base all the areas which you have mentioned.
Thanks, Bilal.
Okay. Who is next?
So, hi Bilal. I am Krishna from Delhi. So, I am a finance professional. Particularly, I am a chartered accountant, and I am a practicing chartered accountant, which is working on the domain of uh, technology supports, primarily on the ISO 27001, and just recently started my journey from the tech side, and as a legal counsel for many banks and BFSI sector as a risk consultant. So I just want to get to know about the DPDPA Act about from the perspective of a consultant side. So how I can be a part of to the organization for the particularly to the significant data fiduciary or the data fiduciary to implement on the data gap assessments and the data you can say data impact assessments, which will be going to be happen once the DPDP Act will be rolled out fully in May to 2027. So this is my objective to learn about this, join this course.
Okay, great. Great. Okay. Anybody else? Okay. Okay. Let me share my screen, and I want some acknowledgement from your side that my screen is visible. Is my screen visible?
Yes.
Okay. Uh, is the blackboard also visible?
Yes.
Okay, great. So again, I welcome you all for this DPDA course. It's an implementation course related to Indian Digital Personal Data Protection Act, also known as DPDA. We will learn about its implementation. We will learn about its principles, the main sections of the law, the legislation, and how it is going to get implemented. What are the different uh, features and what are the different requirements of the law, and how we need to get compliant, how we can fulfill those obligations or requirements as a data fiduciary, and how are we as data principals, how we should act as data principals, and what are our different powers or rights within the law. So as far as the course objectives are concerned, we have divided it into 6 modules. These are 6 areas which we need to explore. If you have attended the webinar, we have also explained these modules there briefly though, but we have highlighted that these are the areas that are the modules that we will be talking about. So it will be the general introduction in the first module about the law, what is DPDA and DPDPA, what is the history behind it, what are the different terminologies and definitions, what is the scope and how it will be applicable, and how it is compared with the other regulations of data privacy. Then we will talk about in module 2, we will talk about the rights and obligations of the data principals and the data fiduciaries. In the compliance and governance part, we will talk about the special category of data fiduciary, which is called as significant data fiduciary. These are nothing but the data fiduciary that process a huge amount of data or a large amount of data and sensitive personal data. We'll talk about data protection impact assessment, about the cross-border transfer, and how we can keep our records, what are the requirements or what are the documents that we should keep, and how we should prepare for the audit. We'll talk about enforcement and penalties. What are the enforcement of the law, how a data fiduciary can be penalized if there is any non-compliance. What is the data protection board? Who are those authorities? We'll have some case studies and some best practices also. Then what about the documentation part or the field work, you can say. This is about data mapping, how we have to do that. You have received a case study of data inventory and data mapping from the operational team. Have you guys received that?
We got
Am
a
I audible?
spreadsheet, Bilal.
Okay.
You're referring to
We
the
have
spreadsheet?
I have shared one sheet which we have to do in the practical part of how we can do a data inventory or data mapping. Have you received that?
Yes, we just received
Okay.
an
So
hour ago.
okay, so we will use that in order to understand how we can do the data mapping, because this is very important, or this is the first step that you have to do. We'll talk about consent management architecture. This is where the main difference lies. when it comes to DPDA Act and the other data protection regulations. We'll have case study for risk assessment or DPIA, also called as PIA, Privacy Impact Assessment. We'll see how the breach response and the breach management response is going to take place. What are the different requirements? What are the cybersecurity controls that we need to apply? How AI, this is the last module, how AI is going to affect AI lifecycle is going to affect DPDPA and data minimization in the A when you are training some AI, Gen AI or agentic AI. What is the notice and what are the different fairness and different vulnerabilities or different risks which are which can get materialized if the privacy is not point of the concern when you are feeding this data or PII, PHID data to the AI system, and how to manage AI risk under the DPDA. Any area you want me to focus more or talk about during the course?
Bilal, can you highlight on how to get implemented? Uh, Let us consider a company who doesn't have any idea about the DPDPA and they want to get it implemented. So if you could highlight that, that would be helpful, and especially focusing towards the company which offers the IT services.
Okay, we can consider that. No problem. Any other area you want me to focus?
So, Bilal, I just want to be focus more about the organization which are using basically the SAP system or the Oracle and different platform where they have integrations. So for the KYCs and for the PI information, how the data discovery it's all about, because currently what I feel while I am discussing with lot of organization, they exactly does not know what are the PI information as such in their system, and what about the old data what they have. So once the DPDP Act will be fully implemented, how they will mask and save the all the data that they have before the DPDP implementations, how they have to handle it. So this is the area where I'm a lot of organization is asking these questions as a practitioner from my side.
Okay.
And second, about the AI uses for these organizations, because especially for the tech companies, or where they are usually a lot of non-tech companies, especially for example the finance professionals, and they are using now Claude or anti-gravity, or maybe a other AI system for their co-pilots they are using. So how these privacy things will be safeguard while using this AI information, while we are working for the organization where this is not a you can say is legally allowable to them, but they are using just for the sake of their convenience.
Correct. Okay.
So this is the idea.
Okay. No
Bilal,
problem.
I have a small question.
Yeah.
So does DPDPA should also be mapped to any other policies like information security policy or access control policy or asset management policy and anything like that, or is it or only to specific policies?
Yes. We will talk about it in detail. Once we are doing the implementation, we will discuss about the implementation, what are those phases of the implementation, and how the information security will overlap. What are the areas that will be more significant to DPDA when protecting the data? Because you cannot have data privacy or data privacy program once you if you don't have the cybersecurity controls. So yes, the overlap will be there. There is a good amount of overlap between cybersecurity and data privacy.
Thanks,
Okay.
Bilal.
So why DPDPA Act? Everybody knows that we are we are a huge economy. Okay, we have around 850 million Indians doing transactions over the internet. Internet is the backbone of the business. There are millions and maybe trillions of transactions going per day uh, in Indian digital market. The companies, financial institutions, health sector, retail, all going digital. And this is the reason that India has, designed this law in order to give the right to the people or to the citizens of the India, so that they will come to know how their data is being used during this digital journey. Because now everybody knows we are going digital, we are going paperless, and in no time in the future we will be 100% dependent on those in these digital assets, and there would be no paperwork in our offices or in our homes. So total dependency on this digital ecosystem has created a need of governing this data which is going into these digital assets. And once these digital assets have this data in the form of our PII and PHI, we as a data owner doesn't have any control or any visibility over that data. So this is the first Data Protection Act or Data Protection Law which has been enforced, which is, it will be fully enforced by next year. So this is the first act which started in 2017, where there was some draft versions which has been created by the Supreme Court judge B.N. Ramakrishnan, and he has created some requirements, or he has created some best practices which ultimately is enforced, and it was approved in the parliament in 2023. There's a huge history behind it, and finally it is enforced. It might be fully enforced in coming time. And this was the reason that the government has taken this step in order for every business or every transaction which is going digitally, so that the consumer or the end user should have a full detailed visibility or transparency of how their data is being used, and what are the rights that they can impose on that data, even though that data is not in their control. So there is a huge penalty for non-compliance, 250 crores, for if any data fiduciary is found non-compliance, or there is any deficiency or any loopholes in the compliance. And it also has a global reach, just like GDPR. It is not locally confined to India. It is applicable to all the parts of the world where the data fiduciary or data controller or organizations, companies who are collecting and processing the PII, PHI of the Indian citizens, this law is going to be applicable to them also. So it is the local geographical scope, which is called as territorial scope, as well as the extraterritorial scope, which is applicable outside India as well. Okay, so every business, every data fiduciary is under the radar of this law. Okay. As I said, there is a history behind this law. It was started with the committee, which is Sri Krishnan committee, B.N. Sri Krishnan. He was the judge of Supreme Court. Now he is retired, and he and his team were experts in the best practices of data protection. So they have drafted the initial rules, which although were, the version were changed till it became the DPDPA Act in 2023, where it was officially approved by the president in the parliament, and then it was took by the mighty organization, which is which published its draft version in 2025. So it was publicly issued as a draft, first draft in 2024 2025. And at 25 it also, by the end of 25, it also got finalized. It was released for the public review in 2024, and 2025 they formed a committee or subject matter experts from the public domain, and they selected some reviewers where the reviews happened, and it was finalized in 2025. Now the enforcement has already been implemented, and it is totally under the control of the government of India, and the Data Protection Board also, which is still to get fully nominated, is also under the central government. So it is currently controlled by the central government, and it is enforced, but it will be maybe fully enforced in from Jan 2027, hopefully. There is no official announcement as such, but the enforcement is already there. Organizations are already starting to prepare for this act, for this program within their ecosystem. What this Sri Krishnan committee has initially proposed are some recommendations. For example, they didn't the current law or the current concept of DPDA Act was not fully inherited from the recommendations of the committee, which have been drafted in 2017, 2018. They have just given the the draft rules, or ad hoc type of rules, which says that privacy is the fundamental right of every citizen. It should be, because it is their own data, and they are the owner of the data, and they should have the choice of using or sharing their personal data. It had a consent-centric framework, meaning the processing will not happen, or the data will not be collected and processed by the data fiduciary unless and until there is an explicit consent from data principals. So you cannot process my data unless and until it is given. I have given you the consent, either through a hard copy or through a digitally signed form, which has been recorded in the backend. You cannot proceed without the notice and without the consent. This is the main difference between the other legislations like GDPR and other laws of privacy and DPDPA Act. Right to individuals, 8 rights are there, which are being given to the data owner of data access, data remediation, data modification, data portability, and all the other laws. We will see it in the data rights, which has been given in that section. Data localization, meaning data will be locally processed within the boundaries of the India. And there would be a governance committee or a governance body or a regulatory body that will be heading or governing how the law is enforced and implemented by the different data fiduciaries within India. So finally, it got into a living document, or you can say a bill is passed, which is quite similar to what has been proposed by the committee in 2018, because at that time it was not fully enforceable, or it was not fully entertained by the government. But now, as the economy grows, and it is a digital economy right now, so they thought that it should be given some seriousness and preferences. So they came up with the DPDPA Act. So you can see there the initial definitions are almost the same. Individual rights have been changed to data principal rights, because data principals are the individuals which are sharing the data. Data breach reporting is breach notification. Significant data fiduciary was also in the initial draft, so it remained the same. Accountability obligation is changed to compliance obligation of under the Data Protection Board. Now, let me tell you what are the basic principles, how we can know the concept of why we need privacy. Okay, suppose we have any organization. Let us take an ABC retail organization. This is a retail organization. We will talk about uh, different companies or different instances or different sectors. But let us take an example of ABC Retail. And ABC Retail is doing what? They are selling food and non-food items, right? And maybe electronics. They have stores, they have the website, the mobile app, and there is a data principle which is Bilal. I am the data principle. So now I need to buy the items, either food, non-food, or electronics from ABC Retail. ABC Retail is a data fiduciary. It's a data fiduciary. I am the data principal. I'm talking about from the terminology of DPDPA Act. So if I am buying some items, I will go to their website and register. I will register. Register as what? As a user. So I will, why I had to register? Because I will get some services from ABC Retail so that I pay them and they give me those items or food, non-food, whatever shopping I need to do, I will do it. Plus, they might have some loyalty program where I can gain some points while shopping with them. So I need to register in their website as a registered user. Correct? So I go their website and register. Before registering, they should provide me the transparency. This is the main principle of transparency principle. Transparency principle and notice. These are the two main items of DPDA. This is the core of DPDA. 2 items plus concept. The base of DPDPA Act depends upon these 2 principles, transparency and notice, plus the consent manager, or you can say consent framework. Now, what is that? If you understand this, you will be able to understand why we are doing the data privacy, what needs to be done during the data privacy, what are the things that we need to keep in mind. So let us talk about transparency and notice. Now, before I register, when I click on register and I provide my first name, my last name, my email, and my, say, postal address. These are what? These are my PII, personal identifiable information. Personal identifiable information. First name, last name, email address, postal address, or in some cases, Aadhaar or some identification. These are called as data sets. Every information, every PII set is called as a data set or a data identifier. data identifier, when they are combined, they will identify this person. They will identify this person uniquely. What does that mean? If first name, last name, email address, postal address, and Aadhaar card will get combined, if I see all these information, I will recognize Bilal as a unique person. Correct? So I am giving them this information during my registration process. And once I am filling this form, they should give me two things. One is transparency and another is notice. Anybody have idea what is transparency and notice?
No, Bilal.
Okay. Now, transparency and notice are the two principles of the DPDA, as I already told, plus consent management. Transparency is that ABC Retail will tell me that if you are sharing this information, 1, 2, 3, 4, 5, we are collecting this information and how, where, when, whom, what. They will tell me how they are collecting, where they are collecting, where they are storing, when they are collecting, also why they are collecting, who has access or whom they are sharing the information, what information they are collecting, and why they are collecting. All the answers, how, where, when, whom, what, and why, need to be answered in transparency.
So this should be during the uh, collection process itself, right, Bilal? Let us say
Yes,
whenever any
without,
user is registering, it should show something like a terms and condition where they need to scroll. And over there, as a data fiduciary, we should be explaining all this. In case if they can accept, we can go with the next step, something like that. Am I right, Bilal?
correct, correct. So
Okay.
before this relationship is built, this is a relationship, right, between me and the ABC Retail, because I'm there going to be their customer to purchase and do shopping and give them business. Before that relationship, he should ABC Retail should give me transparency of how my data is being collected, why it is collected, where it is stored, whom has access, whom they are sharing, what information they are collecting, and why they are collecting. This is the complete, you can say, a map. I have a complete visibility of the data which is being collected from me. That is called as transparency. And it serves as a notice. You can also say the privacy notice. Once they are notifying me that why they are collecting and how they are collecting, what are the security measures, cyber security controls that they are applying, what are my rights in DPDA, and how I can avail them, how I can avail. They should provide me the contact of the DPO or the privacy office where I can get this my rights availed or facilitated. They should inform me about my rights. They should inform me what are the third parties that they are sharing my data with, who has access, who has access to my data. And last but not least, how my data will be deleted, how long they are keeping it, and how they will be deleting it. This information justifies the transparency, and it gives the notice to the it gives the notice to Bilal or the data principal that we are processing your data according to these flows or according to these conditions. This is how this PII is getting transferred or it is getting processed within our system. These are the third parties that we are sharing with. These are the controls that we are applying in order to safeguard that data. And if you want to access your data, delete your data, modify your data, or want any other right to be availed, this is the email address and the contact number of our DPO. And these are the years or number of years that we are going to store it, or the condition that as long as you are our customer, we are going to retain your data, and we will be deleting it after we have this contract where we are doing the registration, because this is a contract, right? This is a registration where you are understanding their terms and signing up with their as a customer. Now, this all information is for what? For me to build a relationship, only for shopping, right? Shopping. I'm shopping, and they have collected this information: first name, last name, email, postal address, and Aadhaar. This is only for shopping and giving me the bill. I should receive this bill either through postal address or through email. Maybe postal address for delivery. Aadhaar are not required in this case, so they should also contribute to data minimization. So maybe they collect Aadhaar, or maybe in some instances they collect Aadhaar. Because I have taken a retail example. Maybe in case of HR, they need, when there is a business process, say recruitment, they may need Aadhaar for identification. In that case, they need Aadhaar. Or
Bilal, what if in case an IT company, there will be users, right, who will be applying for any position. So even in that case, we will be collecting their first name, last name, their email address, and the basic details. So even in that case, we will be considering that applying employee as a data fiduciary in this case. And how long do we need to maintain that data?
Yes. When ABC Retail is going to hire somebody, they are hiring somebody. That hiring, any post, any designation, that automatically becomes data fiduciary.
Okay.
That automatically becomes data fiduciary. So whatever law, Data Protection Act, DPDA, is saying about this data fiduciary, it is saying the same thing about this data fiduciary. So ABC Retail has to maintain all the obligations for his hiring staff or the employees, same, and same for their customers. For him,
okay. What if in case, Bilal, what if in case if the employee doesn't clear the interview? What is the process for that? I mean, how can we drop the data, and should we inform that to the employee who has applied, stating that okay, since you haven't cleared the interview, we are dropping the data? Or will the employee who hasn't been hired can contact and ask us to drop the data something? Because for example, we will be having certain policy, right? In case if any employee applies for any particular opening, within 6 months he cannot be applying for the particular role, right? So how do we tackle in that case?
So as I told you, two principles: notice, privacy notice, and transparency need to be maintained for data fiduciary. Now, suppose a guy who is applied a job of, say, financial controller with ABC Retail. So while he is applying for the job applying and filling his details, submitting his CV, at the end of that job application, there should be transparency and the notice that we are doing this with your how we are processing your data. What is your processing life cycle? This is a life cycle, right? Data, PII or PHI. It has a life cycle. What is the life cycle? Collection, use or process, share, transfer, deletion, archiving or deletion. This is the life cycle, right? So this is a life cycle which you are telling your data fiduciary how your data is getting life cycle, complete life cycle. You will tell the same thing to the guy who is applying for the job, that this is how we are collecting the data, how we are collecting, why we are collecting, because there should be a legitimate interest. There should be a lawful basis for the collection of PII, PHI. That transparency and the notice, you have to give it to him at the end of the job application. There should be the transparency about his collection. And when we are deleting, I told you, when we will delete this data. So deletion for this one, for the customer, will depend upon his contract or his relationship with the ABC retail. But for the candidate, for example, this didn't qualify for the interview and he is not onboarded, his retention will not be of that much. The life cycle of the PII, PHI retention will not be longer. It will be smaller. That's why the ABC retail has to maintain retention schedules, data retention schedules.
Okay.
Or
So
data retention.
within the notice, we need to mention there is a retention schedule for the 6 months where we will be maintaining your records, and after that it gets deleted. Right?
Correct.
Okay.
Correct. That transparency you have to maintain. That's what I told you. You have to keep these two principles in mind while dealing with PII, PHI. Notice and transparency. Maintain transparency with the guy who is applying for the job. Although he is not qualified, he is not onboarded, maybe he is not capable or he has not qualified the interview, but you have collected his data. Tell him that after 6 months, your data will be deleted. And delete that data. Enforce the retention schedule and retention policy. In the retention schedule, you will have a entry for your customer data, which is Bilal, and an entry for the job applicants who are not making it to the final round or who are not onboarded. But these two have different schedules, deletion schedules. This Bilal's data you will delete after there is a a termination of the relationship. He is no more with your customer base, and he applied and he didn't qualify, so his retention period will be small.
Do we need to update the same thing in the organization website also, Bilal, with all this information?
No, you don't need to maintain it. Retention schedule is an internal document. Retention policy is an internal document.
No. Example. Every IT company has their own careers page, right? Whenever they do apply, it should be declared within the website, right? That's what
Yes.
I'm concerned about. In that case, do we need to specify that we are collecting these details and this is a retention schedule we were having?
Correct. In that case, wherever job portal of the organization, there would be a small paragraph saying what will happen to your data. Simple. It's a maybe 4 or 5 liner paragraph where he has to check box. He has a checkbox and he will say, okay. That means he's giving his consent. In DPDPA, you don't have to process without the consent. You cannot process. So you need to show him the map, the visibility under the data privacy notice, give him notice that we are collecting your data and ask him about his permission. That is the consent. And every time you are, as a data fiduciary, you are changing anything in these questions. Now, suppose ABC Retail is not using AI. They are not using AI right now. Maybe after 6 months, they used AI to process Bilal's data for giving him some preferential shopping offers, because they saw he has been there for 1 year and he has shopped these items during this year, this part of the year, during this time of the year. So they will process that data and feed that data into AI. So AI will give them the preferences of Bilal. But Bilal was not informed in the transparency and the notice that your data will be processed by the AI, because at that time the ABC Retail was not using AI. Now ABC Retail after 6 months have got some Gen AI which is processing Bilal's data or customer data. Then they have to update this. They have to update the transparency and the privacy notice. Tell them that now your data is fed as a training data to AI. We are training our AI with your data. Of course, there would not be only Bilal, there would be millions of the customers which ABC Retail has. But at that time also, update this, get the consent. If he is saying, no, I don't want my data to be fed to AI, you cannot, you have to explicit it. You have to suppress the feeding of Bilal's data to AI. That is called consent suppression. That mechanism you should have in his portal. This is this is very, very important in DPDPA, that you should have consent management in place. Not only that, okay, he has given you the consent in the form of a checkbox, and that checkbox remains, okay, it is being calculated or it is being recorded. It should be recorded plus managed. That mechanism should be followed in the backend by your IT or by your infrastructure team, so that once Bilal at any moment of a time he withdraws from the consent, that consent message or that consent on and off, yes or no, should float into the systems and suppress that part of the processing. Whether it is feeding to AI, whether it is profiling, whether it is sharing the data with the third party. Maybe Bilal doesn't want his data to be shared with the third party. He can say, no, I don't give you the consent. Maybe he doesn't want the marketing messages to come in his email or WhatsApp or SMS. That should be explicitly mentioned in the consent, that you will get marketing messages in email, through phone, through SMS, through WhatsApp. Maybe he needs only WhatsApp. He doesn't want email or phone call. So he will uncheck email, SMS, and phone call. That should reflect, the mechanism in the backend should be such that that should reflect in your systems that Bilal has given consent, and suppression should happen for email, phone call, and SMS. Only one yes, which is WhatsApp. All the other channels should be suppressed.
Bilal, is there any vendor or any SaaS-based application that can help us on this thing in terms of collection, removal, and anything like that? Any automated application that is available where companies can use that for all the data fiduciaries?
Yeah, there are many tools which are in the market which can help you in consent management, which has a full-fledged consent management integration with your system.
Can you help me with the name?
I can get those names. I can provide you offline. No, that's not an issue.
Sure. Yeah, thanks for that.
So this is the idea behind this. So I hope there is this is clear now why the data is being shared, when the data is being shared, what are the transparency and notice principles in DPDPA, and how the consent is going to work. Basically, you have to keep in mind that first these two principles need to be fulfilled. And after that, if there is any change, like we discussed, any change in processing, that should reflect in the consent. And consent should be always, it should be consent should be explicit, right? It should be freely given. Always withdrawable. Okay. And it should be recorded. Explicit, freely given, always withdrawable, and recorded. And it should not interfere with the processing, meaning unless and until you will give me the consent, you will not be our customer. Unless and until, in bank, for example, unless and until you give the consent of marketing emails, your account will not be opened. No, it should not be like that. Okay, and you should not have that. That is closely related with the freely given choice.
But there are certain important data like first name, last name, email, and mobile number. So if the data fiduciary is not willing to give that, they may not be able to do it, right, Bilal? What to do in that case?
No, for the essential processing, for example, first name, last name, email, and mobile, and maybe Aadhaar or passport.
Yeah.
This is essential, right? This is essential data that bank need for you to open a bank account. Otherwise, they cannot. This is the KYC, right?
Mm-hmm.
They can mention that this is the explicit this is the essential consent. Other are optional consents.
Okay.
They cannot. It is. That is why it is having a property that is called as a lawful basis. The bank has to, they are collecting this information in a lawful basis in order to open an account for you. Otherwise, they cannot open an account. This should be explicitly mentioned in the registration form, or which the bank is published in on their website. If they are taking registration of the say retail banking, for example. If I want to open a bank account, I will go to the bank account mobile app or the website, and I should fill the form. At the end of the form, there should be essential consent, essential information that they need to open a bank account, and non-essential consents. This is important. They cannot give you service. You cannot build the relationship of data fiduciary and data principal. They cannot serve you, right? After that, after some time, if they want you to get the marketing messages or marketing emails, then you can put that, no, I don't want that. They should be, that's why transparency is very important in privacy. They should tell you that this is essential and this is non-essential. And even if you are not giving us consent in the non-essential part of the processing, we are open to we are happy to open your account. It will not affect the opening of the account. Here they should mention that these are the essential elements we need for processing, and they cannot be avoided. You cannot say I cannot give consent. So it should be explicit, meaning this is essential, this is not essential. Explicit in channels also, say WhatsApp. It should mention SMS, it should mention email, and it should mention also phone call. This much explicit it should be. And whatever you want, whatever channel you want to get subscribed, you can subscribe. Understood? Is this clear?
Yeah, thanks, Bilal. Bilal, is there a way that just like a GDPR or any HIPAA based is applicable in context of a user? Let us say in case if any breach has happened, okay, so we need to notify to the DPDPA, right? Uh, is there a way that the end user will also get compensated for that because of the data breach or something?
Yeah, if that is not clear yet, because it is still in that embryonic stage where it has not developed into a full-fledged enforceable law right now. But yes, there would be amendments and there would be information which is still not clear. For example, data protection board, they have not explicitly declared or nominated who are this, whose body will be. Okay. And for example, breach happened. How much time you have to, in how much time you have to report, that is not mentioned. They have mentioned right now it is immediate. And what does that immediate time, how much time that immediate means, it is not explicitly defined. You have to inform data protection board and data principals, but in how much time, that is not explicitly mentioned. But you
Okay.
have to inform both data protection board and data principals. Now, these data principals will be compensated after the breach is declared that they are guilty. That totally depends upon the investigation that the data fiduciary will undergo with the under the supervision of the data protection board, which is this is a regulator actually. So this is a regulator, so they can investigate. They will of course investigate. They have a group of SMEs which will monitor the or investigate the breach, or they will assign some body in order to investigate for the breach. If it's a big non-compliant, due to non-compliance or something like that, then of course they will decide whether the data fiduciary is guilty. If they are guilty on the non-compliance of, say, data principal rights, for example, then of course they will be compensated. So those lower level details are not right now visible to the public, and they will be, because as I said, it is not that much fully matured. Let it enforce, and data protection board will be just overseeing it. It is not like they will say, okay, we will enforce it from next year and all the data fiduciaries will be implementing it from that point of time. It will take, because data privacy is a very complex it's a complex program, it's a complex project, and it's a total change of the status quo of the organization. It is a change of the behavior and change of the culture. It will take some time, so they will observe it for some time as far as I am concerned, and then they will give some amendments, some leniencies or some concessions. Maybe they will be strict on data fiduciaries, significant data fiduciaries, and they will be giving some discount to the normal fiduciaries. That time will tell. Is
Okay,
that clear?
because yeah, got it. Because the reason why I asked is whenever we develop any playbook or any process document, right? Because these need to be explicitly drafted, so the other business stakeholders are also aware of this thing. That's the reason I did ask this question.
Yes. So as I said, the basic principle of DPDA law first is transparency. And notice. This is the first principle. Second, purpose limitation. What does that mean, purpose limitation? Anybody?
The purpose for which it will be used will be limited.
Yes. So in case of our example, ABC Retail and Bilal had a relationship, right? They asked me about my first name, last name, email, postal address, and I shared with them. And they told me, you will buy things, we will send you the bill on email, and delivery of the goods and items on postal address. This is the initial contract. This is the initial agreement between Bilal and ABC Retail. Bilal will shop food, non-food, electronics items from ABC Retail. In return, he will get the bill. That's it. So my PII will be only processed for bill. This is called purpose limitation. They cannot take this PII and send it to AI. They cannot give it to marketing department for targeting campaigns. They cannot share it with the third party. They cannot use it for some research. They cannot use my PII other than what is mentioned in our contract, that I will buy the things and you will send me the bill, and delivery address will be you, and my postal address will be used for the delivery purpose. If ABC Retail is giving it to AI process for the processing, for training AI, or giving it to marketing to send me the marketing messages and campaigns, targeting campaigns, or sharing it with the third party without my consent, without my knowledge, without being transparently expressed to me, or they are sending it to research, or they are selling it, okay, they are non-compliance. They are violating process limitation. Purpose limitation. Another is data minimization. What does that mean? They collected from me first name, last name, email, and postal address. This is the minimal data, as I gave you example also for the bank. This is the minimal data for sending me the bills and registering me as a customer, because I will get my the points, and I will be able to log in this username and password which I generate. It will be used to log into my account. I will be seeing my sales history. I'll be seeing my purchases. I'll be getting the bills. I will also see what are my loyalty points if they have some loyalty scheme. That's it. This data is only minimally used, or this is the minimal data that are used by ABC Retail in order to serve me with the bill. This is the purpose. This is the purpose limitation. So they should not ask me about my Aadhaar, passport, family information, whether I am married, I am unmarried, or how many children I have. They should not ask me about these things. They should not ask me about the salaries. What is my income? What is my salary? They should not ask me about my office address. Is it essential? Is it essential for them to process my bills? No, it is not essential. So they should minimize the data collection. This is the third principle. This is the third principle of privacy. Every privacy, including DPDPA, should follow this. What is the fourth one? Anybody? Accuracy. Whatever data they are collecting, they should maintain an accurate copy of that data. Meaning data integrity should be maintained. Whatever I am giving them, providing them accurately, they should maintain in their databases. Because finally this data, this PII is maybe in their database servers or in their ERP servers, correct? They should maintain an accurate copy of that data. What is the fifth one? Security controls or security measures. This is where your cyber security will come in. Cyber security controls on the databases, on the ERP systems, on the network, on all those components of network systems where this PII is flowing. They should maintain the CIA, confidentiality, integrity, and availability. This is the core principle of DPDPA Act. What is this?
So Bilal, when you mentioned the PI information, right? Example, especially the cloud services, right? Whenever we are interacting with that, they take the cookie concern, they take nearby location for a couple of applications, uh, and also the webcam. Though they also comes under the PII, right?
Yes, of course. Of course.
Okay.
If the IT company, if there is any IT company who is storing data in the cloud, say AWS or Azure or any other cloud service provider, this becomes data fiduciary, na? And this becomes data principal. So same applies, same concept applies. Now the context is different here, of course. Context is different. Context might be different. See, I am talking about a retail organization. Consider a healthcare insurance company. The context is different, but the principles are same. Maybe I am not getting this data. I am getting treatment code, right? I am getting the diagnosis, right? I'm getting the medical report. This is PHI and sensitive data, right? More critical, more sensitive, right? So these are the items that I will deal with when I am talking about an insurance or a healthcare provider. Bank, for example. Bank. In bank, the PII is what? PII is salary information, transactional history, account number, credit card number, right? So these are the things that the bank will deal with while dealing with the privacy part, or the basic principles. So the with the organization, you will get different flavors of the PII, PHI, but the concept remains the same. Correct? Are you understanding my point? Okay, now fifth one is security measures. What else? What is the sixth one? Storage limitation. What does that mean? whenever I am collecting this PII, how much time I have to keep it in my environment, in the databases, in the network, in the storage, how much time or how long I have to keep them. So retention policies and retention schedules also need to be defined under DPDPA Act. And finally what? Accountability. Accountability means what? The CEO plus the board of ABC Retail will take the responsibility and they give the commitment that we will maintain transparency, we will maintain purpose limitation, we will maintain data, we will implement data minimization, we will maintain data accuracy, we will implement safeguards for the PII, PHI collected, and we will keep it only as long as the relationship with our data principles are maintained. This is the accountability or the commitment, that is the accountability principle that comes from the senior management or the owner of the company. These are the 7 principles under which DPDA should be operating, or it should, it should be implemented keeping these 7 principles in mind. Right? Now tell me one thing. Now I have a question. How CEO and board will give the commitment and take the responsibility? How can they show this? How can they showcase that we are committed?
By ensuring the things required for this compliance are in place, like cyber security and requisite people, requisite reports, requisite documentations.
Yeah, that is fine. That is within the within the program, with the privacy program that we have. We will have different policies, procedures, and guidelines, and deliverables. That is already there. But how they are showcasing it? Because they have to showcase to whom? Data principles, right? They have to showcase to me. I should get that trust that my data, which I am sending to them, which they are collecting, is safe. It is not mishandled. It is not being sold somewhere. It is not being fed to some AI so that I will get affected by that AI later on. I should not get my inbox with the marketing messages. I should not get it full with the marketing messages. I should get this commitment. And how can they give me this commitment? They can give this commitment, and they can publish that in the form of what is called as privacy policy. Privacy policy of the any company is the demonstration of the commitment from the senior management or the owner of the company that we will be committed and we will follow all these principles while your data is with us. Your data, PII, PHI, is completing a life cycle with us. So we are giving you commitment that we will follow all the principles of the DPDPA Act and we will keep your data safe. Your data is in safe hands. This is the commitment that they are giving in the form of a privacy policy. So that's why you will see the privacy policy of the organization on their website. They are conveying you their message, their commitment. And once you are seeing that, it should reflect what? Transparency. It should reflect transparency of your PII, PHI life cycle. The one who, what, where, that all should be visible. Clear? So, what are the key objectives? Individual empowerment. Right? Empowerment means what? You are giving, they are giving you commitment. I told you, they are giving you transparency, plus they are informing you about your rights. So you can avail those rights. Transparency plus availing their rights give you the the empowerment of using your data after it has not been under your control, because when you are giving that data, it is automatically under the control of the data fiduciary. Trust building, right? You as a citizen of the India will see the trust building once you are seeing the transparency and the full life cycle, how my data is getting processed, who is processing it, where it is stored, what are the cybersecurity controls, how it will be deleted. All that you will see in the form of the data privacy policy, and that will build trust. Correct? Innovative balance, it is going to contribute to the economical growth, because we are going to a totally digital era, right? Zero use of papers. Global standard alignment, because now we have DPDA Act and it is enforceable. Now it will help other countries and other organizations doing a cross-border trade to uniquely identify Indian economy protected or guarded by Data Privacy Act. It is giving them the advantage. It is giving the government of India an advantage at the international trade level, where they can do trading with the organizations in other countries which have already matured data protection regulations. For example, GDPR, European Union, already the companies are mature with respect to their privacy programs. Now that India has already being enforced, or it has already implemented and passed the bill, now it will come under, maybe after some time, 1 year or maybe more, maybe 2 years or 6 months, or maybe after 1 year, the adequacy list of the company of the countries which is being right now used by the European Union, India will automatically get added to that adequacy list. Why? Because the law is being enforced and law is being implemented by the organizations within the India. Accountability, it is giving clear responsibility. Now organizations cannot use ad hoc controls. They have to justify, or they have to showcase their compliance with the 7 principles, which I already explained to you, in the form of policies, in the form of procedures, in the form of risk assessment, in the form of audits, in the form of keeping the record of processing activities, which is called ROPA, we will see in the case study, in the form of DPIA or PIA, which they have to do whenever there is any technological change or a process related change or a project related change in an organization or data fiduciary. Are you understanding my point? Now, personal data, we have discussed about it. What is a personal data? A data that uniquely identifies a person, such as name, phone number, location, biometric. There are 2 forms of the data. Let me make it clear to you. There are 2 forms of the data. One is PII, one is, personal data. One is personal data. One is sensitive data. Both are the subsets of PII or PHI. Okay. So you can say your first name, your last name, your email. It's the normal data or postal address. Okay. Your phone or mobile number, your passport number or Aadhaar card. Sensitive data. Any idea about sensitive data? Any idea about sensitive data?
Bank account number,
Medical records.
Health, yeah, your health data.
bank
Okay.
details,
Your bank details, maybe bank account or IBAN number or credit card number. Credit card number. Your salary. Your sometimes some person has criminal records. I'm sorry for the word, but sexual orientation. Religious belief. These are coming under the sensitive data. Biometric. They will all come under the sensitive data. Okay. So there is a difference between these type of personal data. So, but it will be collectively called as PII, PHI. Now, data principal. Data principal is any individual who shares his personal data, PII, PHI, and is uniquely identified by that data set or data identifier or those data identifiers. Data principals are equivalent to data subjects. You might have heard about GDPR. Data subjects, which is the person whose data is being processed. In DPDPA Act, it is data principal. So, for example, Rajesh books a flight, so Rajesh becomes the data principal, right? Now, data fiduciary. Data fiduciary is the one who controls your data, who is controlling how the processing will happen, also called as data controllers in GDPR. They will contribute or they will decide what is the purpose of your processing. Should I use it in profiling? Should I use it in business intelligence? Should I fed it to AI? I will share it with the third party for billing purpose, or I will share it with the insurance. I will share it with the other country, which is not in the company with the other country. I will store it in the cloud or I will store it on-prem. That is totally decided by data fiduciary. These are the organizations that are collecting your data. Now the data processor. What is data processor? Data controller is giving some job or outsourcing some job to a third party or a second party, that is called as data processor. In our case, for example, we had a company, ABC Retail, right? ABC Retail was having Bilal's data, but they decided, you know what, let us give it the billing to a company XYZ billing. They are doing the billing for our customers. We don't have in-house bandwidth or in-house resources. So for the billing purpose, we will use another company, XYZ. So XYZ is processing Bilal's data. So this becomes the processor. Bilal is not dealing with XYZ. Bilal is dealing with ABC Retail. He is the data fiduciary. Data fiduciary decided that billing should go to XYZ. They can do that, provided what? Now here is the catch. What is provided? Who should know? They shared the data to XYZ for billing. Whom they should inform? Whom this ABC Retail should inform? Are you with me?
Yes, sir.
Yes, sir.
Whom they should inform? Who should be informed? That we are sharing the data with the XYZ.
Data fiduciary.
The principal.
Data processor.
Data processor. This is data processor. This is data fiduciary.
Yeah, the company is a data fiduciary.
This is data principal. Whom should be informed? Who should inform who? My question is, who should inform who?
We have to let the principal know that your data is now being managed by XYZ.
Correct.
Is it correct?
Correct. Bilal should be informed that your data is being, I told you, who, what, why, how, when. These are the things that I should be informed. That is what transparency is, right? Now, if they are after 6 months of a time with my relationship with ABC Retail, they outsourced billing. What they should do? I have read data privacy policy, privacy notice or privacy policy before 6 months. I have read that. Now, at that time, 6 months before, they don't have this processor in place. After 6 months, they outsource it to XYZ. What they should do as a part of DPDPA Act, they should maintain this transparency. Now, what they will do? They will update this policy. They will update this policy saying, we have been sharing your data with XYZ company. Earlier we were doing it in-house, now we are sharing it. So this will be added to their processor list in the privacy notice. So in order to maintain transparency, they should inform me that your data is being shared with the XYZ. Are you getting my point? Are you with me or confused?
Understood, sir.
So this is the transparency principle that they have to maintain and give me the notice that now your data is being shared. Right?
One question, sir. When we are notifying that now your data is going to be shared with XYZ, what is the mechanism where the principal has to be told that your data is going to be shared? Is it an email or some how are you going to let them know that, so that tomorrow we have notified our principal that the data is now going to be shared by somebody else?
Now, if the data is being shared after 6 months of my relation, now the data is being shared with the processor, they should update. This is the first thing. They should update the privacy notice. This privacy notice got updated, right? This is a document. Now, this document is in the mobile app, right? On the website. And I have an account. I told you I am registered. I have an account. So once I log into my account through web or through mobile, the first thing that I should see before entering my account or before login to my account, I should see an updated privacy policy. Updated privacy policy asking me to read this. And in that, I should accept it. At the end, I should accept it. Why? Because it is being updated. Why? Because the data is being shared with the third party, which earlier I don't know. Are you with me?
Understood, sir.
Now, if they are doing now with my this one with my PII, they are doing now profiling. They are doing profiling, or they are feeding it to AI.
Okay.
Earlier, they were not doing it. Now they will update an AI. For AI and profiling, they will update what? Privacy notice. At the end, they should ask me about the consent for two things: AI profiling and AI decision making. I should give them consent. Otherwise, they cannot do neither the profiling nor AI automated decisions. Many times you have seen there in the bank, you are using a mobile application from the bank. Sometimes you cannot open the account or you cannot open the app unless and until you update, right?
True, sir. But okay, I understood, sir. But the problem is the privacy policy can be that vast. It's quite unlikely that people will just do a blank check, agree, and go ahead. So fundamentally, the principle are that the fiduciary has got the approval, but it has not been explicitly mentioned that now your data is going to be profiled through AI or is being shared by a third party. But okay, I got the picture. At least from a compliance point of view, we are doing what is required in terms of updating the policy and letting whenever the user logs in next, he has to automatically approve and go ahead. Understood.
Yes, understood. From the fiduciary point of view, it is their job to update it, and this is their the demark where they will end their demark.
Understood, sir.
But there are some duties, we will see it in the slides also, some duties on Bilal also, that okay, if they have asked me to see the update of the privacy policy, definitely there will be some change. Either they are doing profiling with my data, or they are feeding it to AI, or they are sharing outside India, or they are sharing it with the third party. Let me read it. Let me see what changes they have done. There are some duties on the data principle also in the DPDPA Act. So, and we should not neglect that. We should be aware about how our data is being processed. It is not only data fiduciary that has been obligated under the DPDPA Act. It is the data principles also that has been given some duties. Although there are some powers given or rights given to them, you can avail them. You should know those rights also. But at the same time, you are also given some duties that you have to abide with the law. You have to be cautious how your data is being processed. Right? Now, there is a special category of the data fiduciary which is designated by the central government, that these are the organizations that they are dealing with sensitive data or huge number of PII, and they are seen with the special lens or special status given under the DPDPA Act, or they are more liable or more obligated than the normal data fiduciary. So if they are banks, financial institutions, healthcare providers, cloud service providers, fintech companies who are processing large amount of data, then definitely they will have a special status. What is the special status? Significant data fiduciary. They will be more strict. Government will be more strict in enforcing the compliance on these data fiduciaries. Consent manager. Consent manager is a special, you can say it's a differentiator, and it's a good thing in DPDPA Act. I personally like this, that you are maintaining a data fiduciary has to maintain or the government itself, or somebody, there is a gray area right now. Who will be the consent manager under DPDPA Act? Who is going to maintain this status? Is it the data fiduciary, or it is the data protection board who will nominate somebody where the central location of all the consents of the data principal will come, so that you don't have to go and uh, you have five, for example, 5 6 subscriptions. You are subscribed with bank, you are subscribed with travel agencies, you are subscribed with airlines, you are subscribed with retail. You are maintaining your digital presence with all these companies. If you want to have any opt out from any of these services of these different sectors or different areas of data fiduciaries, you have to individually give or opt out of those processing channels, right? But here is the main differentiator, is the consent manager. It's a central uh, kind of manager or management of the consent of the data principles. So you have to log into that data, to the consent manager, maybe a DigiLocker. I have heard that DigiLocker, like something like that, will be there as a consent manager, who will be maintaining the managing the consent of the data principles, and they can log in and opt in and opt out. Okay. Now, comparing it with the GDPR. Okay. When we are comparing it with, we are seeing jurisdiction is India, because it is Indian Act. It is being enforced and implemented in India. That doesn't mean that it is going to be localized only in the Indian jurisdiction. It is applicable over the globe, where you are touching the data PIIPH of Indian citizens. Okay, so this is the jurisdiction, India and European Union for the GDPR. Data controller term or data collectors is data fiduciary in DPDPA Act, and data controllers, as I already said. Lawful basis, consent, and 2 legitimate basis: transparency and notice, plus the consent. 6 lawful basis. I have described those 6 principles, 7 principles already under DPDPA. Okay, so those 6 principles of transparency, purpose limitation, data minimization are the lawful basis of GDPR. Only for the significant data fiduciary there is a requirement for DPO. Otherwise, the companies could maintain data privacy program without DPO also. But in case of GDPR, there are certain controllers, and it is up to the organization's hierarchy and their distribution over the European Union territory and outside the European territory that persuades them to designate a DPO or a data privacy office. Data localization or data transfer, it is up to the central government right now. As I told you, it is still in that ad hoc, or it's still that initial stages. We have no visibility about how the data transfer is going to happen. Whether in case of GDPR, as I told you, there is an adequacy decision. There is a list of the companies that you can transfer the data under GDPR, meaning they are applicable in countries, or they are adequate and countries to transfer the data. But no such case in the DPDPA Act. There are also standard contractual clauses, also called as SCCs, and binding cooperative rules under which you can transfer the data, but no such thing right now for the DPDPA Act. 250 crore of penalty, 20 million euro or 4% of the annual turnover. Which one is greater is the penalty for huge non-compliances or major non-compliances under GDPR. Children's age is under 18 and parental consent is needed in DPDPA Act. While as in some areas there is an age of 13 to 16 in GDPR, they are considered as minors. Okay. Data breach notification, as I said, immediately is written in the article right now, but we don't know what that immediate means, how long and how quickly, what is the time limit under DPDPA Act. But we have to inform as long as there is a suspect that a breach has happened and there is confirmation that PHI is compromised, they have to immediately report it to the Data Protection Board. But whom, how, and what should be the notification format, that is still not clear. In GDPR, there are 72 hours that is called as the golden period in which you have to investigate. In 72 hours, you have to report it to the supervisory authority. And in that case, if you have huge amount of data breach happened, you have to inform to the data subjects as well under GDPR. Is this clear?
Yes, sir.
You want to take a break?
Yes, sir. 10 minutes is all right, sir. You can check if the class is there.
We can take a 15 minutes break. And after 15 minutes,
Sure.
we can
Sure, sir.
come back.
Okay.
Thank you.
Thank you.
We can start now.
Sure, sir.
Yes, sir. Okay. Now, as far as the scope and applicability is concerned, it has both the local scope or a territorial scope and extraterritorial scope. When we talk about territorial scope, as I said, it will apply to all data fiduciaries that are processing the PII, PHI within India. That means if I am sharing my information with any of the organizations within India for any processing, it will apply to that, which is of course but natural. And it will also apply to the organizations outside India which are processing the PII, PHI of the Indian citizens. So it will be applicable for any e-commerce platform, e-commerce organization. It can be applicable to any SaaS-based platform which is hosted outside India in European Union or US or Australia or Africa, any part of the globe other than India, or overseas firms, organizations which are doing some kind of processing outsourced by the Indian data fiduciaries, outsourced to the other cross-border transfer has happened, and they are processing the data, then it applies to them as well. So in nutshell, it is like a GDPR. GDPR was enforced not only in European Union, but it was enforced in other parts of the globe as well, where they were processing the PII, PHI of the European Union citizens and residents, right? So likewise, the DPDPA Act also has two scopes as far as the jurisdiction is concerned. Is this clear? Any questions? Any questions so far? Any questions related to previous discussions?
One question, sir. When you said cross-border, right? Now,
Yeah.
quite often we do have a lot of our consumers' data which is stored in Salesforce, correct? Those cases, now I was reading somewhere that if the other country has its regulations, we look at their regulations, or DPDPA gets applicable to Indian citizens which data which is stored in Salesforce. How do you what is the understanding of how is that protected when we are storing Indian data on Salesforce? They say that we have an Indian instance, or we don't have an Indian instance, or it is stored in US or UK or wherever it is. In that case, how would we have to ensure that those data is protected when although we are collecting the data in India, but it is actually being stored in wherever our tenants are maintained?
Yeah, in that case, if data fiduciary is doing any kind of business or any kind of business relationship with outside or the Indian territory, say in US or in UK, then of course they have the European Union territory already have GDPR. So GDPR principles are almost, as we say in this slide, they are almost comparably same. There is no difference. Okay, but only thing that what an Indian fiduciary has to maintain with the data controller or the data processors, because in that case they will be the data processors. They will have to showcase to them that they are already fulfilling the requirements of data privacy DPDPA Act, but under the lens of the data privacy regulation which they are following. Meaning, I explained to you the principles, right? The 8 principles. Now, the Indian fiduciary who is doing an agreement, data protection agreement with a organizations who is in US or in UK or any other part of the world, they have to mention or document in the DPA agreement, data protection agreements with the processor, that what are their responsibilities in handling this data, how this data will be protected, what are the controls and what are the process controls and technical controls that will apply to the data once the data is in their jurisdiction. They can also mention the right to audit to that organizations which is processing the data on behalf of the controller. That means the controller from the India data fiduciary will go and do the audit either by themselves, or they will hire a third party, maybe a big four, and they will go and audit the processor residing in another country, and that auditor will see how the data protection program or how the data is being handled by the data processor.
Noted. So one question, sir. If the data is being stored in Europe, then we have presumably most of the entities who are processing our data, Indian data, in Europe, generally have to follow GDPR. So fundamentally speaking, we are fundamentally safe there, correct?
Correct, 100%. This is like if European Union company is already, whether a processor or a controller or a partner with the Indian fiduciary, they are already following GDPR. That means automatically they have 90 to 95% or maybe 100% compliant with the DPDPA Act.
Okay. The problem lies if you're going to US, because US as a country does not have a central GDPR or DPDPA affecting
Yes.
US, correct? Then
Yes.
it's like Singapore would have a different, they have a PDPPA. Australia has a different, so we'll have to basically go on the regulations for those individual countries, and then we'll have to, do we have to compare that, okay, DPDPA and PDPA for Singapore is meeting its requirements or not, and then, so although my Salesforce or whatever is storing the data in Singapore, but as a fiduciary, I'm collecting my data from Indian consumers, but it is stored in the instance in Singapore. So that's where I have a constant. I've been looking for this, but I don't get. You have given me the answer on the European side. I'm looking at how do we look it on the US side, and similarly, how do we look it on any other country where my instances might be stored.
Yes, that is what I told you. It is the responsibility of the data fiduciary in India.
Okay.
They have to maintain the privacy language in their data protection agreements. They can send an auditor, or they can hire an auditor in that country, and that auditor can go into the premises of that country, of that organization, and audit them on the basis of DPDPA.
Understood.
Meaning they will check the requirement, but that requirements are, that will be mapped to GDPR, for example.
Got it.
Okay. So they have to showcase that, yes, the requirement of DPDPA of transparency, for example, or notice is being fulfilled by our privacy notice. Data minimization, for example, how they are doing data minimization. Auditor will ask them about those controls, evidences, records, and processes which is supporting data minimization in that country by that organization, so that they will compare it, because it's a mapping, right? So they will compare it with the DPDPA Act requirement or section 11, 12, or 13 are being compliant with that.
Makes sense. Perfect, sir. Thank you. Thank you, sir.
Okay. Welcome. Okay. Now, as I told you already, two key principles of transparency and notice requirement remains the key part of the DPDPA Act. Okay. So what data is being collected, how it is collected, the entire life cycle you have to, you have to define, or you have to describe or give the visibility to the data principle in the privacy notice, and you have to maintain the transparency in front of the data fiduciary. This is very important under the DPDPA Act. So now the data privacy policy or data notice which you are publishing on your website, this should clearly be stating that what data we are collecting, what is the lawful or legitimate interest of this collection, and how this will be processed further, how you can exercise your rights, how you can withdraw your consent or you can opt out, and how you can reach us in order to avail the rights which you have been given to you by the DPDPA. This should be clearly mentioned in the privacy notice. Privacy notice should always be updated. Privacy notice should contain these segments: what personal data, the life cycle of that data, what is the purpose of the processing, why we are collecting your data, what purpose it is serving us, and how you will be benefited by sharing your data. Okay, and the contact details of the DPO, very important, because if I had to avail my rights, I should know whom to I have to contact, and I have to send email, and what are the different channels that I can send them those requests. I need to change my data, how I can change the data. And very important part is there are processes which I need to when we do the implementation slide, I will tell you, but I need to mention it here. As far as the processes are concerned, it applies to DPDPA Act, plus it applies to all the other data protection regulations, including GDPR. So what are the main components of the processes or procedures that you should maintain under a privacy program? First is the data subject access procedure. This is the most important procedure that a data fiduciary should have. Meaning there should be a proper procedure how the data subject will ask for their rights and how it will be processed. In GDPR, it is the 30 days. 30 days. In DPDPA Act, I think it is 15 to 20 days that has been given to data fiduciary to complete the data subject access procedure, DSAR, also called as DSAR. Okay, so you should have this procedure documented. Okay, you as a DPO or a privacy officer should maintain these or create these documents, and you had to maintain. The second thing is consent management procedure. Consent management procedure. You as a data fiduciary should know how my consent procedure should work. Meaning, if I have to ask the consent, what are the different channels that I have to ask the consent from? What are the different channels and the different processes that is going to give me, there is called as central consent management platform. Organizations has to maintain this platform, where that platform is a central location, where all the channels will be updated from different processes. For example, marketing, customer relationship, CRM, HR, maybe in the bank, for example, or from a health insurance company, for example, claims. In the bank, there are retail banking, for example, retail banking. all should be integrated with this consent management platform. It should be a central platform where all the APIs with these, for example, marketing campaigns should have API which should talk with the platform. CRM should have an API that should talk to the platform. The retail banking department, they should have an API where the customer is opting out and or opting in, that should talk to each other in order to receive those suppressions and updates, so that the suppression of the consent or the application of the consent happens. This is the second procedure that they should have in the data privacy program, including DPDPA. Third one is data breach management procedure. Breach management procedure. This is the breach management. When there is any breach, how the organization will send the notices and information. Notices to data protection board and data principals, or the data principals. It should be integrated with cybersecurity incident response management or incident response procedure. Closely related with that. Because all the information of the breach will come from the cyber and IT team. So they should, the DPO or the privacy officer should be able to integrate between the cyber incident management procedure and the data breach management procedure, because then you have to send these notices within the particular time. Right now that time is not defined, but it should be immediately to the data protection board and then to the data principals. And these should be, these three procedures, very important. These should be regularly tested for their SLAs. For example, a breach notification within the 72 hours. Within the 72 hours, I should inform, for example, the regulator. This SLA automatically becomes less than 72 hours. Now, the breach management, consent management, and DSAR, they should be tested before implementing them in the live environment. So you as a data privacy officer should be able to draft these, document these procedures, and then test them. Because these testing SLAs will also get fed into your KPIs. These SLAs will be helpful in measuring your DPDPA implementation. Measure of DPDPA implementation. How your performance of DPDPA or privacy program is going on, when you will test these and when you will derive the KPIs out of it. Because you have to measure, you can measure your privacy program or DPDPA Act with the parameters or the metrics derived from these three important procedures. Are you understanding my point? Any questions? So how many procedures you will be, you have to create or you must create? These three should be minimally, these three should be there. These are also the deliverables also. The auditor which is coming to you to audit your DPDPA will ask for these procedures. They will check for these procedures. They will check if they have been tested. Are you able to meet the SLAs of these procedures or not? Clear? Rights and obligations, I will take it after we will do this this part. Why is this implementation? Okay, now consider this. This is the organization chart of ABC Retail. You are here. You have a team, privacy team. You have business units, HR, operations, customer care, and finance, marketing, and IT department. You also have internal audit. You have board of director plus CEO. You have been appointed as a DPO, right? Your job is to implement what? DPDPA or a privacy program within the retail organization. You are part of this organization. Now, tell me where you will start, how you will start. How you can implement the DPDPA Act in this order. Do you have any idea about how to start it?
First, I think we have to do the gap assessment, what the
Okay.
current status we have at organization level, and what is the requirement from the DPDPA. The first to identify the gaps and then go for the plugging of these gaps.
So, now you are seeing these departments.
Yes.
All these departments are one way or the other processing the PII, right? What you will do as a DPA, initially, you will have the project business case, right? You will make a business case that you have to do what? DPDPA implementation. And here you will define your requirements, your risks, your legal obligations, right? What else? Your return of investment, your cost of implementing it. You will define everything. You will define the solution of implementation of DPDPA. This is the first thing that you will do, right? Because you have to justify why DPDPA is applicable to you, what are the requirements, what is the legal obligation, what are the risks, including the legal risk, what will be the cost of our implementation if you are outsourcing it for with a consultant or with an external firm, and what you will get in return. This is done, right? You get the approval. You get the approval for what? For your business case. Now, what you will do? What is the second step you have to do? Second step you will do, you will see what are the departments in the scope. Who are processing PII? Who is touching the PII? Right? Then what is the third step? You will select or you will nominate data champions. Data champions from, what are data champions? These are the privacy coordinators. These are the privacy coordinators. Maybe these are data champion 1, data champion 2 from HR department. Data champion 1, data champion 2 from operations. You have to reach these guys and tell them that I need 2% or 1% from your department who I will nominate or I will use for data privacy program. Why? They will ask you why you need. You will ask them that this is the business case that I have created. These are the risks and these are the legal obligations, and I have the approval from the senior management. I have to implement this program, and for that I need data champions. Now, who will tell me why I need data champions? Why I need these guys? Any idea?
Because they are process owners, sir. So it's better they are, I mean, you build a capability of risk right into the individual processes. So it's much more better to, they are more, it's like a PISO role for them. So they are basically part of the process. So as when things change, they are the ones first person to notify us.
Correct, because these data champions are what? They are knowledgeable about their business processes. They know how the business process works and how the business process is injected with PII. They know what are the business processes and how it is touched with PII, or how PII is touching my business process. Now consider the DPO. DPO does not know what are the business processes of HR. HR business processes, as I told you already, recruitment, payroll, maybe visa services, maybe medical insurance. Are these business processes touching PII?
Yes, sir.
Yes, they are touching PII. Right? PII is getting injected in these business processes. Recruitment, we saw. What are the PII that is being touched by the recruitment process? Candidate first name, last name, email, qualification, maybe Aadhaar or passport. Who knows this? The guy who is doing the recruitment process in HR. Operations, maybe customer service or happiness center, or maybe the call center, or maybe finance. Finance is doing part of the payroll. So salary information, payroll is touching the business, the PII. Yes, salary information, bank details. Who knows about this payroll? DPO? No. The guy who is within the finance department handling payroll. That's why you need data champions. Why you need data champions? Because later in the project, you have to do what? You have to do a record of processing activities, right? What is that called? ROPA. You have to maintain that ROPA. That ROPA is what? It is an inventory of your PII. How your PII is being used. Who has access? What are the systems that it is stored? Whom it is shared? What is the legitimate interest? Is the consent being taken? Is it shared with the third party? That is the map. That is the inventory of that PII. Who will do that? Who knows that? These data champions. So from each department, you will nominate data champions, because ultimately record of processing activities, DPIA, DSAR, consent, who had to do this? You as DPO? You as DPO will do this? No, you will not do it. You will supervise it. Once your DPDA program is getting matured, you will supervise it. You'll make sure that ROPA is being maintained. DPI is being done when there is a technological change. Consent is being taken and being managed by the department data champions. Are you with me?
Yes, sir.
So all these data champions will help you in execution of DPDPA, or you can say privacy program. When business as usual will come after the implementation or operational phase of your privacy program will come, these data champions are your workforce that will work for your privacy program. They will maintain your ROPA, they will maintain the DPI, they will do DPI, they will do the DSAR if the request is under their data, under the ownership of their data. They will also help in you the data breach management. So this is the workforce that you have to select. This is the step number 3. What is the step number 4? Now what you will do with these data champions? Do they know what is ROPA? Do they know what is DPIA? Initially, I'm talking about initial implementation. You are not in operation, you are in initial phase. You are implementing. Now, they know what is ROPA? They know what is DPIA, DSAR, consent management?
No,
They
not
know
at the
about...
moment. At the moment, no, you'll have to explain it to them, build a playbook for them, right?
They don't know about privacy, right? They don't know about this DPDPA.
Exactly.
What you will do? You will run awareness program. Why you will run awareness for them? Because this is your team. Later on, when you will be in operational phase, this will be autopilot. You will be just facilitating and making sure your parameters, your metrics are being met, your KPIs are being met. Your program goes flawless in operational phase, but now you are in implementation phase. You have to keep them ready or keep them aware, train them how to do ROPA, what is DPDPA, what is data principle, what is data fiduciary, what is DPI, how to do DSAR, why consent. So you have to make them aware about DPDPA program. This should be a technical awareness. Technical awareness. Make sure you have to run this awareness program for 3 types of audience. 3 types of audiences. Who will tell me what are the 3 types of audience? A, B, and C. You have to run awareness programs throughout the ABC retail, entire organization. What are your 3 types of audiences? Are you seeing them? Are you seeing here? What are the three types of audiences?
Yes, sir. You'll have
What are
leadership. You'll have leadership. You'll have to have a
okay?
program for leadership. Then you'll
Senior
have to
management,
senior management. True, sir.
data
Then
champions, which you selected, data champion 1, data champion 2. Now this guy is not data champion, he's an employee, normal employee, right? He is an employee, other data champions. This is data champion employee. These normal employees, they don't have to do anything with the ROPA. They don't have to do anything with the DPIA. They don't have to do anything with the consent or breach management. But they have to do something that is called as data handling. Data handling. PII, data handling. They should know about PII. They should know how to handle the data. They should know how the data can be compromised. They should know about the cybersecurity controls, acceptable usage policy handling PII, PHI. Right? Normal general awareness about privacy. So three types of audience: senior management, data champions, and normal employee. You had to run these awarenesses, You don't have to run, you run these awarenesses. This one will be the high level. This one be technical. Technical means specific to privacy program. This one will be normal general awareness. General awareness about privacy. You have to make sure they are knowing about their privacy policy, that privacy policy exists. What is the privacy policy? What is the aim of the privacy? Because auditors will go into the three types of audiences to check if the awareness has been properly dissipated. Are you with me?
yes, sir.
Yes,
Right?
sir.
So this is the fourth step in your implementation. I generally follow this approach because this is giving you the you can say the later on you will be at ease as a data privacy officer or a privacy program manager or a consultant. You can work in all these things initially. You can plan them initially, and then you will see that autopilot is automatically on. So awareness programs, 3 awareness programs, make it technical, make it high level for the senior management, and then the general awareness about the employee. What is the 5th step? Now I am already selected the data champions, right? I have already given them the awareness. Now I can start with the gap assessment. Gap assessment is nothing but you have to run through your DPDPA requirements or sections. This will give you the idea about the initial state, what is your current state, and how much effort and time is needed in order to reach the final state or the destined state or the compliant state. This is nothing but you will run through the requirements, how the transparency, how purpose limitation, how storage limitation, how accuracy, how all those requirements, which is highly, I have explained them everything in the previous lectures. I have explained to you the 7 principles, for example. So gap assessment based on the requirements of the DPDPA. It is the 7 principles is the crux of their DPDPA. Plus other requirements, for example, consent, record of processing activities, DPIA, DSAR procedure, consent management procedure, data breach procedure. These are the main pillars of your gap assessment or main requirements of the gap assessment. So now the gap assessment is done. You will come to know what is the effort and what is the time needed in order to reach your compliance state. But this time is what you have to, because it is a green field. For example, ABC Retail doesn't have even the privacy policy. So you will start with drafting the privacy policy. You will start drafting the procedures. What are those procedures? I told you. So as far as the deliverables are concerned, or the requirements or the documents which are concerned, what are those? Privacy policy. Right? This is very important, mandatory. In this privacy policy, you will showcase your transparency. And it will also showcase, what it will showcase? One is privacy policy, one is privacy notice. Any idea what is the difference? Sometimes you will see privacy policy and sometimes you will be also seeing privacy notice. ABC Retail might have privacy policy. It might apply to the internal staff. It might have privacy notice, or interchangeably it might have privacy policy for their data principles. Or if I talk about 27701 ISO, it might be for their external interested parties. Are you aware about ISO 27001 or 27701?
Yes, sir.
So let us talk about interested parties. These are nothing but the stakeholders. Data privacy, data principals are one of the interested parties of DPDPA, or in context of ISO 27770. So for the external world, it can be privacy notice, because you are notifying your privacy, data privacy principles about your transparency. And one more thing, what is this privacy notice or privacy policy serving? What is this serving also, as far as those 7 principles are concerned?
Information to general public.
Yeah, that is transparency, right? That is transparency. You are maintaining a transparency, showcasing a transparency with the privacy notice, right? Or privacy policy. It is the context is different. Internal staff, it might be privacy policy, because when the auditors will come, when these guys will come and audit, say, department directors or your data champions, for asking different things about ROPA, DPIA, consent, DSAR, they will ask about, do you know about the privacy policy which we have? First thing is transparency. It is showing transparency, plus it's also showing accountability. Accountability or responsibility or commitment from these guys, that we will be maintaining a privacy program. We are committed to support our privacy program and continually improve. Right? The accountability is what? Responsibility to take the ownership, right? If something goes wrong, who is accountable? Senior management, right? So they are giving you accountability, also building trust. Accountability builds trust with the data principles, right? So it will give you the effort and time needed in order to create those deliverables. What is the second thing that you have? Data mapping. Or PII inventory. In this stage, you will come to know, this is a workshop actually. This is a workshop with whom? This is the workshop with these guys, departments. Each department who is handling PII, PHI, or who is using business processes which is using PII, PHI will be under this workshop, data mapping. Okay. What is the third thing that you have to do? Record of processing activities. It is actually the output of the second one. Record of processing activities. This is the record of inventory. Inventory of what? PII, PHI. Okay. What other thing that you have to do? You have to create procedures. What procedures? I already told you. 3 procedures, 3 important procedures. Consent management procedure, DSAR procedure, and breach management procedure. Parallelly, you have to work on these procedures also. Vendor management. Vendor management, third-party risk and data protection agreements. 2 things, 2 very important things. Third-party risk assessment, risk management, and data protection agreements. You have to create these data protection agreements under the vendor management, and you have to create a risk assessment methodology by which you will do the risk assessment of your vendors. Are you with me? Are you understanding, or you are confused, or you are not understanding the flow?
Yes, sir.
So this covers your third party vendor management, also called as processors, right? Because the data fiduciary will give data or hand over data to the processors. But are those processors or third parties capable of handling that data? Because if they are breached, they will not be penalized. You will be penalized as a data fiduciary. Do you know that? If ABC Retail is handling, I told you the billing was given outsourced to a company XYZ. So all the billing of the customers, the data will be shared with XYZ. Now ABC Retail has to do, now it is not only one processor that they might outsource. There are many processors. So they have to do the one thing is data protection agreements. They have to create these template of the data protection agreements where they have to specifically mention the terms and conditions or the language of privacy. It should not be only the commercials only. No. Plus data privacy rules, responsibilities. You had to create the DPA in such a way that commercials are okay, that is already discussed, but these are data protection agreements. So you have to discuss what is the role of the processor, what is the responsibility, what we can ask for, what they have to submit every year, how this commercial agreement will be depending upon the data privacy rule. If there is any risk which is violating the data protection agreement or violating the DPDPA requirement, then the contract or the suspension of the third party or the processor will take place. Second thing is third party risk assessment or risk management. You have to perform these two while dealing with the processors. If they have some gaps which will come under this one, you have to give them some time, or depending upon the severity of the gap, it can be immediate, it can be after 1 month, or it can be in 1 week. You have to highlight those gaps. And if they are critical, you have to suspend what? Contract till they will fix those gaps. Very important under DPDPA. Are you understanding my point? Is this okay the way I am explaining the things, or I should go as per the slides?
I think it's okay, sir. I think it's good, sir.
Absolutely fine.
So this is the third thing that you have to do in case of your, as far as your program or the implementation is concerned. Other things which are related to cybersecurity policies. Cybersecurity policies should be created, or it should already be there in place. Only thing now you have to see the controls which you will have to implement on securing or protecting the PII, PHI, which you are collecting or processing within your systems, within your digital systems or IT systems. Okay, cybersecurity policies and cybersecurity controls. You have to make sure that are aligned to what? As I told you in the beginning, there is an overlap. There is an overlap between cybersecurity and data privacy. It will come under the implementation of those privacy requirements or privacy risks that will be giving input to your cybersecurity controls. What are the other things? DPIA. DPIA is data protection impact, data privacy impact assessment. It's a kind of a risk assessment which you have to do every time there is a technological change. Sorry, there is a technological change and or process related change. Right? Input from DPIA will go to your cybersecurity controls. Who can explain me how? Suppose I have done the DPIA. DPIA means risk assessment when there is a change, right? Or input from ROPA. ROPA can go to cybersecurity controls. Can anybody explain how?
So, because once the risk has been identified where the problem lies, then accordingly the compensating controls will have to be changed, sir. So that
Correct.
would eventually go ahead and change your risk assessment, your access management, your overall information security policies. All that will have to be changed piece by piece.
Very true. Very true. So consider a ROPA. ROPA you have done and you came to know that you are storing the data. What is the ROPA? As I told you, it's an inventory. We'll do it in the case study tomorrow. So that will give you a clear picture that once the ROPA is done, you will come to know whether your data is being stored in the server. Which server? Say there is a database server. Now you are storing PII, PHI. Now the question is, if this is stored, is it encrypted or it is in plain text? Now, if it is not encrypted and if it is in plain text, automatically that will raise an alarm of the risk or the gap, because this PII, PHI need to be encrypted if it is stored. So if it is not encrypted, or if it has a not role-based access control is not applied on this server, everybody can access it. There is no role defined who will access the data, PII, PHI data. Then again, it is a raised alarm. There is a raised risk. So it will go as an input to the cybersecurity policies and controls so that encryption will be applied or role-based access control will be applied. Or suppose if this database is not on-prem, it's on the cloud. Now again, if it is staying in the cloud, whether the encryption is applied or not, if it is in encrypted form or a closed or in plain text form, and what is the agreement between the cloud service provider and ABC Retail in this case, or the data fiduciary, so that are these responsibilities defined, because we are losing the control of ownership when the data is being transferred to the cloud. Are those responsibilities or data protection agreements, which I told you here, data protection agreements, where is it? Here. And the third party risk management has been done or not. If that is not done, then again, it is going to raise an alarm, and you have to change the policies or you have to change the controls, cybersecurity policies or cybersecurity controls. Okay, so DPIA and ROPA both will give you the idea about the risk. What else? Performance management. You have to implement. You implemented from step number 1 to step number 7, and including these steps 1, 2, 3, 4, 5, and these deliverables. Now you will see whether your program is going as per the requirements or as per the acceptable level, or there is any deviation. It is going above threshold, or it is reaching the threshold or above threshold, or it is not reaching that threshold. It is deviating from that threshold. That means your performance is having some deficiencies, or the program is having some deficiencies. You will measure your program. How you will measure the program? Anybody? How you can measure the program, privacy program? This will serve as one metric. Awareness. Awareness will serve as one of the metric of the performance. ROPA, updated ROPA, as I told you, updated. It is a live document every year or every 6 months or every change, because this is a record of processing activities. It is a business process record, list of the business processes that is touching the PII, PHI. If that is updated and you are having an updated inventory of your ROPA, naturally you are maintaining your compliance. DPIA is done. Every technological change or every project or process change is preceded with DPIA. So you can measure your privacy program with the DPIA perspective. From the angle of the DPIA, you will see what are the different projects that has been done by the marketing department, by the operational department, by the IT department, and each phase it has been proceeded. Each project is proceeded with data privacy, data privacy impact assessment. DSAR. Can you measure DSAR? Can you measure your DSAR? measurement of the DSAR, percentage of percentage of success of DSAR, number of DSAR fulfilled or closed within 30 days divided by total number of DSAR. Because you have a 30 days period or a 70 days period or 50 days period, whatever time period you have in order to fulfill the requirement of your data principles. What are those numbers which you have fulfilled and what are the total numbers of DSAR received? That will give you the success rate of your DSAR. That you can feed into the performance measurement. That will become one of your metric in the performance measurement. Awareness. Suppose total number of staff is, how you can measure awareness? How you can measure awareness? Any idea? So awareness.
Quizzes, part of your
By
overall
asking questions.
key questions. Yeah. And then basically building up a survey, how many people answer this question, and then saying that, okay, 100 people, I got 90 people who understood, and that's how awareness is increased or decreased.
No. That is effectiveness of the awareness. Number of staff attended awareness divided by total number of staff. What is the total number of staff that has attended awareness divided by the total number of the staff? That will give you the success rate of their awareness. Now, effectiveness of the awareness, that will depend upon the how many person have passed the quiz which you have given after the questions or the whatever test or quiz you have done after the awareness. That will give you the percentage of effective awareness or the percentage of the vulnerable users which have not understood your awareness. They have not understood the content. But for the awareness that you have dissipated awareness or you have made sure that your data champions are aware, your employees are aware, your senior management is aware. This is how you can calculate and feed it to your performance management, your metrics. And finally, what you will do? Not finally. Now, after that, you have to do the audit management of your privacy program. And finally, continual improvement. Continually improve your program. After the audit, there would be some non-conformities. You have to close them and you have to make sure those non-conformities are closed within the set time so that you are continually improving your program. These are the main steps of your implementation. Tomorrow we will do the case study. We will see how the data mapping and data inventory is created in an organization. That will give you the idea how the ROPA will be made and how the DPIA will be conducted preliminary, not actually, not exactly, but it will give you an idea about the DPIA also. We'll derive the concept of DPIA from data mapping, ROPA, and then the ROPA. Any questions?
No, sir. Thank you.
So I will stop here. If you have any questions about today's session, I hope I have been informative, and I am not. I'm not reading from the slide. I'm doing this approach. I hope this has been understandable by you.
Yes, sir. Thank you.
Yes, sir.
Okay, I'll see you tomorrow. Tomorrow we'll also do this data mapping, data inventory part.
Sure, sir.
And thank you for your time. I'll see you tomorrow, 8 p.m. Indian Standard Time.
Yes, sir. Thank you. Have a good day.
Thank you very much.
Bye-bye, sir.
Thank you. Bye.